morning, everyone, and welcome to today's seminar webinar as regards data protection issues in internal investigations. Just a couple of ground rules, if I may, before I embark on the talk. I will try to address questions at the end of the talk. What we would ask is, if you have any questions, pop them in the chat function, and between us, Olivia and I will attempt to identify them and go through them. Obviously, if there's anything that arises from the talk that you'd like further clarification on, at the end of the talk, my contact details are there, and I'm happy to address any queries by way of email, assuming I know the answer. So, data protection issues and internal investigations. Having undertaken quite a few investigations, data protection is an issue which consistently rears its head, and there is an issue between either absolute fear at the risk of subject access requests and data protection issues in the context of investigation, or at the other extreme, there are sometimes occasions where no thought's been given to data protection issues at all. And the purpose of this talk is effectively to identify the sorts of issues that are going to arise in an internal investigation, and to, as it were, generate ways of thinking about the issues, the responses, and the appropriate responses thereto. So, what I'm going to look at is, number one, what is personal data? I'm then going to look at the key data protection principles. Number three, and this is probably going to be the meat of the talk, is to look at the lawful bases for data processing in the context of an internal investigation. Four, we'll look at practical planning for the data protection issues that are likely to arise. I'll then look at some specific common problems. And the last thing is what to do at the conclusion, involving how you respond to the dreaded DSAR, which sadly is a regular feature of investigations work. Now, it's also important to recognise that the data protection provisions are not the sole question that will need to be considered in the context of an investigation about limitations or access to limitations on the use of or access to information. So, for example, legal privilege, which is a whole nother talk in the context of an investigation, is something that's going to need to be considered. If you are dealing with a local authority or public sector employer or organisation in the context of an investigation, the Freedom of Information Act may involve requirements on that organisation to disclose data. If you've got an environmental context, the Environmental Information Regulations may apply. You've got to think about common law duties of confidentiality and rights of privacy. You may have a statutory obligation to keep information confidential, and the general catch-all recognise Article 8 of the ECHR deals with rights to privacy, which again is going to be a relevant factor in most investigations. So recognise those additional points, but here obviously the focus is on the GDPR and data protection legislation. So, number one, personal data. What is personal data? Well, here we see the definition from Article 4.1 of the UK GDPR. I shan't read it out. I dare say you're all able to read it for yourselves. And you will appreciate that personal data is an extremely wide concept. It's basically anything which allows an individual to be identified. Having identified what's personal data, what is processing? Again, Article 4.2 of the UK GDPR, an extremely broad concept. And it's probably not overstating matters to say it's doing absolutely anything as regards personal data, including erasure or destruction, as you will have seen from the last two words. What's the effect of this? Well, the effect of this is it is hard, it's hard to envisage an investigation which shall not involve the processing of personal data. let's choose an example, a deliberately extreme example. Even if you're not investigating conduct of some sort, and let's face it, most investigations you are, but if you're not, and for example, you're looking at compliance with Know Your Clients checks, you will still need to review and obtain evidence from individuals. You will still need to review emails and messages, all of which involve or include personal data. And remember that personal data includes factual information and opinions about a person. So in any investigation, data protection is going to need to be front and center in terms of your contemplation. Next thing, we need to identify who it is who's in control of the use of data. So a data controller is a natural legal person who determines the purpose and means of processing of personal data. That is to be contrasted with a data processor. And a data processor is effectively a natural legal person who is told what to do with the data by the controller. So the obligations on a processor are far less onerous than the obligations on a controller. So who are the data controllers in an investigation? As I've said, the controller is the person who decides how and why personal data is used. And in an investigation, that is usually going to be a combination of counsel and solicitors. Looking at my own perspective or the perspective of counsel, counsel will be a data controller because they will be involved in the agreement of the provisions of the terms of reference. They will procure evidence through documents and interviews, and they will decide how it is processed in the final report, because the writing of the report is data controlling. So one of the things that it is worth thinking about at the start is where there is an allocation of responsibility between counsel and solicitors in terms of data controlling. It's a sensible point to address it in the terms of reference, and I'll deal with the terms of reference in more detail later on in the talk. But it's sensible to identify who is responsible for what elements of data control. For example, if there is a subject access request, which of the two, be it counsel or solicitors, is going to be responsible for meeting the data subject's rights? And any such agreement ought to be available to the the data subject, in order to ensure that they are aware who's doing what. So having dealt with the concepts of personal data, data controller, data processor, we now move on to the data protection principles. And these need to inform the approach to any investigation. And you'll see they're set out in Article 5 of the GDPR. Again, I won't read it out because you're as capable of reading it as am I, but it's important to recognise what are the limitations. There has to be a lawful, fair and transparent processing of data. It must be processed for a purpose or in a manner which is compatible with the purpose of the processing. It must be accurate and maintained to be accurate. It must only be processed for as long as is necessary for the purpose of the processing, and it must be its integrity and confidentiality must be maintained. So a series of layered and relatively onerous requirements, I would suggest. And the data controller is accountable for the nature of the processing in that regard, or controller processing, yes. Now, we then get to the nub of the issue in the context of investigations. There needs to be a lawful basis for all data processing. There's no possibility of an exemption from that requirement. and recognise that if you're dealing with special category personal data, which I'll come to shortly, there are additional requirements for the lawful processing of that material. So there are a series of there are a series of lawful bases of processing, but the ones which are most likely to be relevant in an investigation are the ones I've identified here. So consent, necessity for the performance of a contract, compliance with a legal obligation, protection of vital interests, and necessary for the purposes of legitimate interests. And we're going to now look at each of those in varying levels of detail. So, consent. The reality as regards consent is, rather like the old maps which used to say, "Here be dragons" at the top, the point is, avoid consent unless there is no other lawful basis for processing, because there are considerable difficulties in relying on it. Consent must be clear, specific, informed, and unequivocal. And it might be difficult to show at the start of an investigation when you're not quite clear what you're going to do and how you're going to do it, or where directions may take you, to demonstrate that that degree of clear and unequivocal and informed consent exists. It's unlikely to be available as a lawful basis of processing if there is an obligation on the part of the employee or the individual who's the subject of the investigation to comply with the investigation, because consent must be freely given. There's also the very big problem that it can be withdrawn at any time. And if it's withdrawn at any time, arguably requirements of deletion are triggered. So what do you do in those circumstances? Interesting question, of course, is if in the context of an investigation material were disclosed under consent, which triggered SRA reporting obligations by way of example, and then there's a withdrawal of consent, what would you do in those circumstances? Interesting question, yet to be resolved. So I would suggest only rely upon consent if there's nothing else to which you can point. And all the more so if you're dealing with special category personal data. And as I say, we'll talk about what that is in a moment. Performance of a contract. Now, this requires the contract to be one to which the data subject is a party or prior to the entry into of such a contract. So, for example, a contract of employment may require an employee to partake in an investigation, but it's unlikely to apply to an ex-employee. And so you're going to need another basis for employees who have left before or during an investigation. Compliance with a legal obligation doesn't include a contractual obligation, because as we've seen, there's a separate provision as regard contractual obligations. So it can arise from a legal or regulatory obligation. The obligation must be on the controller who relies upon it as a lawful basis. So really what you're looking for is a very clear basis at common law or at statutes. Protection of data subject vital interest is realistically very seldom going to be available, because the ICO guidance says, the ICO's view is this only applies in life or death situations, which is generally, in my experience, not going to be the case in an investigation. So the lawful basis that you are most likely to be called upon to consider in the context of an investigation, I'd suggest, is that it's necessary for the purposes of legitimate interests. And this basis allows processing of personal data unless it's overridden by the fundamental rights of the data subject. So the onus is upon the data controller to balance the legitimate interests that it seeks to further against and consider the necessity of processing the personal data, and balance that against the interests of the data subject. And the ICO proposes a three-stage test. So the first question is there a legitimate interest behind the processing of the data? Secondly, is it necessary for that purpose? And thirdly, is a balancing exercise, is that legitimate interest overridden by the individual's rights? Now, you'll appreciate that those concepts are all nuanced and are going to be fact specific. So we're now going to look at some of the ICO guidance in this regard to see if we can identify the extent to which these rights are also these obligations are going to exist and capable of being balanced. So, number one, what's a legitimate interest? Well, effectively, a legitimate interest is capable of being anything. And as the ICO says, it applies in a wide range of circumstances, and it places the onus on the data controller to balance their legitimate interests and necessity with the rights of the data subject. And so what does the ICO say about this? Well, it says a wide range of interests may be legitimate interest. It could be your legitimate interest in processing, legitimate interests of a third party. A third party doesn't always refer to other organisations. It could be a third party individual. It can also have regard to the wider public interest. And the point that is made there is the more that your legitimate interest involves a public interest, the greater the weight that is properly to be afforded to it when you come to the balancing exercise, which later is going to be required. However, it's not a carte blanche. So what the ICO says is, because the term legitimate interest is broad, the interests don't have to be compelling, although in some interests they will be. Also, in some circumstances they will be. And so the fact that it is a legitimate interest, it could be a relatively trivial legitimate interest, but if it is, then it's going to be more difficult to satisfy the need and for processing and the balancing exercise, which later comes when weighing the effect of the processing against the data subject's rights. It is interesting to note, however, this is the second paragraph, showing you have a legitimate interest does mean, however, that your authority must have a clear and specific benefit or outcome in mind. It's not enough to rely on vague or generic business interests. You must think about specifically what you are trying to achieve with the particular processing operation. So bear that in mind. Your legitimate interest must have an objective, and when you're assessing the necessity test and the balancing exercise, the extent to which your legitimate interest is achieved by those is going to be extremely relevant. So what are the legitimate interests that traditionally might arise in the context of an internal investigation? Well, recital 47 of the UK GDPR points out that where a data subject is a client or in the service of the controller, and you have an existing relationship which is relevant and appropriate, that is something which is going to feed into the assessment of whether a legitimate interest exists. Now, legitimate interests which I suggest are traditionally going to arise in an internal investigation are, number one, conducting a fair and transparent investigation. There's an obvious interest in all parties and the public in that being the case. Seeking to reach a correct conclusion on the facts. Everybody in an investigation is going to want that, one would have thought. Compliance with obligations under the ACAS code or disciplinary or grievance procedures, again, legitimate interests. Potentially investigating criminal acts, and from the perspective of counsel or solicitors, meeting their professional obligations and following their instructions. Now, all of those, I suggest, are plainly legitimate interests. So the next stage of the analysis is the processing necessary to meet that legitimate interest? And unsurprisingly, the ICO guidance says necessary means necessary. It doesn't have to be absolutely essential, but it must be a targeted and proportionate way of achieving your purpose. And the guidance goes on to say, you need to decide in each case whether the processing is proportionate and adequately targeted to meet the objectives. And if there's a less intrusive way of doing what you seek to do, then the necessity test is not going to be satisfied. Further guidance from the ICO: you shouldn't confuse processing which is necessary for your stated purpose with processing which is only necessary because of your chosen method. So you've got to distinguish between your purpose and your method. And if there's a different method of achieving your purpose and it's not necessary to process the data in those circumstances, you're not going to satisfy the necessity test. And as the ICO says, it's important to be clear and specific about what your purpose is, because if you're clear and specific about that, that informs the necessity of the processing. Final point: if processing is not a reasonable way to achieve your stated purpose, then the legitimate interest doesn't apply. So more reasonable, less invasive, it's not necessary. So ICO example: many of you may recall a few years ago when Jeremy Corbyn was the leader of the opposition, and he posted a photo of himself walking through a train, suggesting that there were no seats available because everything was reserved. The train company wanted to use CCTV to rebut this inaccurate version of events, so it had a legitimate interest in disclosing the CCTV footage to all the news outlets. The question was it necessary for them to disclose the CCTV in the manner that they did? And the ICO said no, because they disclosed the faces of all the commuters, and it wasn't necessary to disclose the faces of the commuters to make the point that they wanted to make. So bear in mind that in this context, blurring of faces and the like would have rendered the processing necessary. But the fact that the data minimization principle wasn't met led to a breach. So having identified legitimate purpose and necessity, we then move to the balance test. And we see here, just because you've determined that your processing is necessary for a legitimate interest doesn't mean that you are automatically able to rely on the basis for processing. You still have to engage in the balancing test. Interestingly, looking at the last sentence, in essence, this is a light touch risk assessment to check that any risk to individuals' interests are proportionate. So you see there, light touch. You've got to think about it, but so long as you can demonstrate you've thought about it and it's not obviously erroneous, hopefully the balancing exercise ought to be sufficient. Recital 47 of the GDPR comes in again, talking about a suitable or an appropriate pre-existing relationship. And it's suggested that the extent to which a person would reasonably expect further processing is going to inform the balancing exercise. And it's an objective test. What would the reasonable person expect in terms of processing in the circumstances? This is a point. I'll suggest in due course that in any investigation you ought to issue a privacy notice. And the privacy notice ought to deal with the sorts of processing which is likely to occur, because that then informs the extent to which the data subject would reasonably expect the processing, which is going to be a relevant factor in the exercise of the balancing test in due course. So here we have an example from the ICO guidance, and I won't read it out, but broadly what you'll see is that when somebody sends a CV to a recruiter looking for a job, even though they haven't expressly said, oh, you may share my CV with employers for the purpose of finding me work, it's the sort of thing which a data subject would reasonably expect in terms of processing. And that informs the balancing exercise. Two caveats, however. Reasonable expectations is an important, by the way, this is taken from the ICO guidance, I should have made plain. Reasonable expectations is an important factor, but it doesn't automatically determine the outcome. simply having told the individual what you intend to do doesn't give you carte blanche. You've still got to engage in the purpose, necessity, balancing exercise in all circumstances of processing. But the flip side is, even if the processing has a negative effect on the individual, that doesn't mean that their interests always override yours. It depends on the severity of the impact, the compelling nature of the processing, and if your reason is sufficiently compelling, it may justify some impact on individuals. Example of that from the ICO guidance is, again, won't read it out, you can read it yourselves, but I'll summarise it very briefly, namely, individual who defaults on a loan, loan company wants to locate the individual and passes their personal data to debt collection agency. The point is made that the finance company has a legitimate interest in recovering its money and ensuring that individuals meet their obligations. The individual in question has a legitimate interest in their information not being shared. But in the balancing exercise, it's obviously appropriate that the debt collection company pass on the data to, that the finance company pass on to the debt collection company because they have a legitimate interest in recovering their money. Interesting point. When you are dealing with the balancing exercise, the ICO guidance talks about a need for a serious mismatch between your interests and those of the individual in circumstances where the individual's rights are stronger. So, interesting, I suggest, that in the balancing exercise, in the absence of a serious mismatch, it's much more likely that the balancing test will be satisfied. And you're really looking for a serious mismatch in order for it not to be appropriate to process data, assuming you have a legitimate interest and the processing is necessary. But of course, caveat at the end, the outcome will depend on the circumstances of the case. 'Twas ever thus. So, once you've dealt with your legitimate basis, recognise two subsidiary rights. Number one, the right to object, and also the right to restrict. Now, if a subject a data subject seeks to object or restrict the processing of data, then you can only continue to do such or engage in such processing if there are compelling legitimate grounds for processing, or processing is for the establishment, exercise, or defence of legal claims. Now, we'll look at what that means in a moment, but likely in many investigations to be a criterion which will be satisfied. Now, all of what I've been saying up until now has been in the context of, if I could put it this way, general personal data. Special category personal data, more onerous obligations apply, and you will appreciate in the context of investigations, particularly in the employment sphere, special category personal data is likely to be something which is at least considered. It may be front and centre in, for example, a disability discrimination complaint, which we'll come to later. So it includes racial or ethnic origin, religious or philosophical beliefs, trades union membership, data concerning health, data concerning a natural person's sex life or sexual orientation. If you've got special category personal data, processing is generally prohibited unless you can satisfy the conditions in Article 9.2 GDPR. And the four relevant ones are explicit consent. I've already dealt with the dangers of consent generally, all the more so in the context of SCPD. It's necessary for the purposes of carrying out the obligations and exercising specific rights of the data subject in the field of employment and social security and social protection law. Manifestly made public, again, limited scope, or is necessary for the establishment, exercise, or defence of legal claims. Now, I said I'd deal with what that meant, and we'll come to that in a couple of slides' time. So what does the ICO say? Well, the ICO makes the obvious point that the more sensitive or private the data is, the more likely the processing is to be considered intrusive or create significant risks. And so in those circumstances, the more compelling the reasons that are going to be required to use this type of data, and the greater the need to take adequate safeguards. And I'll talk about what those safeguards can be in due course. And again, obviously, if there's a less intrusive way of going about your goal, then you should take it. So the ICO gives an example of the use of personal data in the context of an investigation, or forgive me, seeking legal advice by an employer. And it makes the reasonable point that if there's alleged misconduct against an employee, it is reasonable, necessary, and generally is going to satisfy the balancing test to send that to solicitors for their advice. Now, that is obviously a different example from an investigation. It doesn't specifically address the context of special category personal data. But plainly, if you've got an investigation where the special category personal data is material to the investigation, and an obvious example is if somebody asserts that they've been treated in a manner which amounts to disability discrimination, then it is likely to be necessary and to meet the balancing test for you to process that special category personal data, subject to appropriate safeguards. And as I say, I'll talk about those in due course. Now, what is defence of legal claims? Well, the ICO guidance adopts a broad definition and says it includes processing which is necessary for actual or prospective court proceedings, obtaining legal advice, or establishing, exercising, or defending legal rights in any other way. So recognise that when you are formulating your terms of reference, if you have an internal investigation, particularly in the employment sphere, where there is an allegation by an individual which is said to involve some sort of unlawful conduct, let's assume discrimination in this context, then it is likely that you will be able to satisfy that test, because most investigations are going to be carried out to establish liability or the prospects of bringing or defending a claim that may, and they may be able to rely on this provision. So in the context of special category personal data, how necessary is necessary? Well, the same point, the guidance is effectively the same. Doesn't have to be absolutely essential, but it must be more than just useful or habitual. It must be a targeted and proportionate means of achieving that purpose. So think, can I do this in another way or in a less intrusive manner? And if the answer to that question is yes, you're going to have difficulties in satisfying the necessity test. Two or three other concepts we need to look at are fairness. You must process data fairly. And the ICO's view is that fairness is demonstrated by considering how the processing may affect the individual and handling the personal data in a way that they would reasonably expect, and explaining whether any unexpected processing is justified. Transparency. There are minimum requirements of transparency in Articles 13 and 14 of the GDPR. And if it's not clear, the data subject has the right to withdraw or delete data. And so transparency is also going to be relevant to the question of fairness. And this is another factor or another issue which is best addressed, I'd suggest, in the privacy notice, which, as I'll explain in a moment, you should definitely get signed by the data subject. Also, if something new arises which you haven't anticipated during the process, you should raise that with the data subject and effectively seek to get their buy-in. For example, if you haven't previously said, I'm going to share your interview transcript with someone else and it becomes necessary to do so, inform them of that fact and try and get their buy-in. But it's important to recognise that transparency informs consent, but is not the same thing as consent, because consent has to be clear, unequivocal, etc., as I discussed earlier. So, having looked at the data protection landscape, let's look at some practical planning in the context of investigation. The first thing to consider are the terms of reference to counsel. First and most important question, who is the data controller and who needs to ensure compliance? Is it counsel? Is it solicitors? Is it both of you? If it's both of you, in what respects? What about privilege? To what extent is legal professional privilege likely to apply? Could litigation privilege apply in the context of a claim where litigation is reasonably in contemplation? What types of personal data are going to be collected? So if you have a disability discrimination complaint, are there going to be medical records? Is there going to be a need to look at GP notes? Is there going to be a need to look at medical reports from professional examiners? Do you need a data protection impact assessment? Now, it's obviously a useful tool if you do one, because it shows that at the very start of the process, you've gone through a question of what processing am I going to undertake, why, and how am I going to go about it? And it's useful evidence if there are complaints about data protection issues, if the ICO should come a knocking. What's the purpose of the investigation? What are you there to do? Or what is the investigator there to do? How are they supposed to go about it? Who's going to collect the evidence and how will it be stored? Will interviews will there be notes? Will they be transcribed? Will they be recorded? If they're recorded, will it be an audio recording or a video recording? How is personal data going to be shared? With whom is it going to be shared? And also, how is the outcome going to be shared between the parties? Now, all of those things, if considered and recorded at the outset, are incredibly useful tools in then engaging in the, if it's a legitimate interest assessment, in identifying the legitimate interest, in addressing necessity, and also in engaging in the balancing exercise. Remember that the terms of reference will define the purpose of the investigation, and the purpose limitation in Article 5 is going to be hugely important, because you can only process data in a manner which is adequate, relevant, and limited to what is necessary in relation to the purposes for which they are processed. So the purpose will restrict what personal data can be used and why. Because if you process personal data in a manner which is incompatible with the purposes of the investigation, then your legitimate interest and is difficult to satisfy. Also, the necessity test is perhaps more difficult to satisfy, but also you would fall foul of the purpose limitation. So the terms of reference need to be framed in a manner to ensure that if there are further steps that are contemplated, that they can properly be said not to be incompatible with the purpose of the investigation. What about sharing? Now, think about data subjects. Natural justice in an investigation may require the sharing of either interview transcripts or material which has been generated by the data subject or provided by the data subject in an investigation. Example, allegation, somebody's done something, data subject says no, and in fact, here's the email that demonstrates I didn't do that. That's provided to the investigator. It may be considered reasonable by the investigator to put that email to the person who first made the allegation for their comments on it. So it needs to be explained, or it needs to be considered and explained to individuals that in appropriate circumstances, personal data may need to be shared. How is that personal data going to be provided to the client? If you have an international context, think about data sharing in that regard, because special considerations apply if you're seeking to share personal data with, across international boundaries. What about sharing with regulators or law enforcement? May that be required? What about the final report? These are all matters to which thought I would suggest should be given. What about security? Because remember, the 8 principles include an obligation of data security and data confidentiality. So you need to take appropriate steps to ensure security. How are you going to share documents? Who are they going to be shared with? For example, the terms of reference could sensibly identify a core group of individuals with whom information can be shared, and then provide, if it's going to be shared outside that core group, how it will be shared with them. Think about the need for agreements with third parties. For example, if you're sending a video recording to transcribers to transcribe, ensure that they have appropriate security measures and appropriate confidentiality provisions. When sending invitations to individuals for the purposes of an interview, inform them of confidentiality obligations in their contracts or elsewhere, requiring them not to discuss and share the contents of the investigation. So I've said on a few occasions, or I've addressed on a few occasions, the importance of a written privacy notice. And my suggestion would be, in any investigation, issue one to all persons involved in the investigation as soon as possible. In the privacy notice, detail what you intend to do and how you intend to do it. Identify what categories of personal information shall be accessed and why. Deal with the question of how interviews shall be recorded and transcribed. If you think you're going to need to access special category personal data, inform the individual of that fact and why you intend to do it. Tell them with whom data may be shared and why. Detail the legitimate interests that you rely on for the purposes of processing. If you're going to process special category personal data, explain why you think that will be appropriate. As I've said on several occasions, do not generally rely on consent, but indicate that if you are going to rely on consent, it will be sought and will be specific, targeted, etc. Deal with your retention period. And most importantly, get them to sign it and send it back to you, because that is going to be powerful evidence if you enter the realms of an ICO in criticism or investigation, in terms of your ability to say, well, look, I thought about what I was doing and why I was doing it, and that's why you ought to have regard to what I say when I subsequently say I've weighed matters and I've concluded that there was a lawful basis, it was necessary, and the balancing test was satisfied. So, common issues which arise in investigations which pose data processing issues. Number one, many investigations, you get individuals who seek anonymity. First question is, if you agree to it, as regards whom? Obviously, anonymity as regards the investigator is unlikely to be possible or practical. The ICO views pseudonymization, thank you, I think I've got that, as a useful tool to limiting data risks. But obviously, what about natural justice? Because, take this example. An individual is accused to have assaulted somebody in a pub, let's say. The individual says, I need to know who it was. And a reasonable point might be, if it's person A, they can say, well, yes, I have been in the pub with them, but I've never assaulted them. If it's person B, I know that can't be true because I've never been in the pub at all with them. And so there may be circumstances where anonymity is going to cause reasonable natural justice issues in the context of an investigation. And what about equality of arms? Is it reasonable, fair, and appropriate that somebody can make allegations under the veil of anonymity? You'll obviously need to weigh that. If an assurance of anonymity is given and considered to be appropriate, recognise the possibility that a data subject might subsequently be identified, and that might provoke data protection issues, because if you've not alerted them to the possibility that their anonymity might not be complete, there's an argument that you haven't processed data in a fair or transparent manner. So there's all sorts of difficulties in terms of anonymity from a natural justice and equality of arms point of view, but also a data protection issue. And the suggestion I would make is discuss it with the subject, explain the limitations of what you can and can't do, and seek to secure their buy-in and make sure that that discussion generally takes place in interview and is recorded. Recognise also there might be circumstances where statutory anonymity applies. For example, if there's a sexual offence which falls within the Section 1 of the Sexual Offences Amendment Act. Akin to anonymity but different therefrom is off-the-record discussions. Now, in any investigation, the first question is it fair to allow somebody to have an off-the-record discussion with an investigator? My own view is generally it's not something I encourage, but that doesn't mean that's a universal rule. Of course, views may reasonably differ. But what about the difficulty if there's a challenge to the accuracy of the off-the-record and there's no record of those discussions because, believe it or not, they're off the record? What about consistency issues? And recognise that if you do take notes of an off-the-record discussion, they may still concern third-party data and may be susceptible to a subject access request. So it may lead to disclosure of the documents in response to such a subject, or at least the information within documents subject to a subject access request. So again, if that's something that you decide to do, discuss, explain the limitations and make sure that those limitations are recorded. Transcripts and recordings. Well, the obvious point about a transcript is it's going to involve the personal data of the interviewee, the subject of the investigation, the interviewer, and all other persons named within it. And so a data subject is in principle entitled to access the transcript or the recording. So ask yourself, are you going to have somebody there to take notes? Well, if you've got somebody taking notes, you then end up having the marvellous discussions about whether the notes are accurate or not. So should you record it? Should it be an audio recording? Should it be a video recording? If it's video, why does video give you something that audio doesn't? The answer generally would be, well, you can assess demeanour and you can't do that simply from an audio recording. But you need to address your mind as to why it's necessary to have a video recording. The terms of reference may tell you that's what you're required to do, which would be obviously helpful evidence in that regard. If you have a video, might it show special category personal data which is not relevant to the investigation? So think about that in terms of what you do about any video recording. And if you've dealt with all of this in the terms of reference and the privacy notice, it's very helpful because the individual comes knowing what you are intending to do and why you are intending to do it. So transparency is important. If there is an objection, and I had a case involving Belgian employees, and there are a series of procedural requirements in Belgium where there was an objection to a video recording. And so we had a discussion. In the end, agreement was reached, and we had a written record of the agreement, which obviously helped in terms, or would help in terms of any complaint, which I very much hope won't arise. Recognise that a video is a particularly intrusive form of personal data, and agree deletion protocols. So, for example, once your transcript's agreed and you've formed a view of the witness as an investigator, do you really need to retain the video? Probably not. Another issue is, of course, individuals who separately record meetings. My suggestion is that you should prohibit that. And of course, there's all the authorities suggesting that that might be misconduct of a separate kind in any event. Disability. Most of the investigations that I do are in the employment sphere. And very, very frequently, I've come across circumstances where an individual wishes to assert disability discrimination, but then suggests, well, you shouldn't share my personal data, my special category personal data, which deals with the nature of the disability and the effect that it has upon me. What you've got to do is obviously balance the data protection rights of the subject with natural justice to the accused. So ask yourself, are there alternative sources of the data Do you reasonably need to provide this to other individuals to assess the case? And how material is it? So, for example, if you have a reasonable adjustments complaint, one of the factors which is relevant in assessing the reasonableness of the adjustment or whether the duty is owed at all is whether the employer knows or could reasonably be expected to know of the disability and the effect of the PCP on the individual. In that kind of case, it's much more likely that you will need to share special category personal data in order to give the individual said to know what is necessary to that which is necessary to be known, to give them the chance to answer whether they do or they don't. Contrast that with, for example, a disability harassment case, where it's not necessary that you know that somebody is disabled to harass them by reason of it. So again, it's a factor you're going to need to consider and weigh, and very much have in your mind the data minimization principle, namely only show them as much as is absolutely necessary, which neatly leads into the next point, which is redactions. Now, in an investigation, my general view is that natural justice requires that persons accused of serious things have the opportunity to see the evidence in support of it. But recognise that in an investigation, there's likely to be a whole raft of allegations, and as regards individual Y, there may only be 2 allegations. They therefore don't need to see all of the material generated for the purpose of the investigation. So consider necessity. If you've got particularly special category personal data, which is not material, restrict what individuals see. If there are parts of documents that they need to see, but parts that they don't, redact them and be prepared to explain what you redacted and why, because you'll need to balance the data subject's rights against natural justice and be able to explain, well, this passage was necessary because this passage wasn't necessary because. So, what to do at the end? Well, recognise that a data subject has a right, as regards all of their personal data which is processed, to access it, to seek to have it rectified, to seek to have it erased, and a right to restrict processing or to object to processing. And recognise there are no formal requirements for an individual to exercise those rights. You can't contract out of them, but they're not absolute rights. A balancing exercise is required to be performed. So we come to the dreaded DSAR, which is something of an occupational hazard in investigations. The first and most important thing to recognise is most DSARs are, in my experience, are used as a vehicle of litigation. But the right to access is only to personal data. It is not to documents. And there is no obligation to disclose information which leads to the identification of another individual or which is privileged. Although you can disclose information if you have consent or it's reasonable to disclose without consent. So when you're assessing the reasonableness of a disclosure, consider the nature of the information, any duty of confidentiality owed, steps taken to seek consent, and the capacity to give consent. And it is perfectly fine if you have, for example, a 20-page document and there is one sentence which refers to a data subject. It is perfectly fine to redact the remainder and simply give them that part of the document which refers to the data subject. Because remember, it's the right to access personal data, not to access documents. Also recognise the potential application of confidentiality under paragraph 19 of Schedule 2 of the GDPR. So there is no obligation to disclose information if it is in respect of which a duty of confidentiality is owed by a professional legal advisor to a client of the advisor. Query: is counsel in an investigation a legal advisor? Well, it's not clear, and there's no ICO guidance on this point, but it does seem that information which is held subject to professional duty of confidence is likely Not certain. There's certainly arguments either way, but I'd suggest is likely to be information that can be withheld in response to a DSAR. So what do you do? Well, if you get a data subject access request, firstly, consider whether personal data is being processed in relation to the subject, likely to be the case in an investigation. Decide or note who is the controller. If you've got joint controllers, whose obligation is it to meet the subject access request? If you are the data controller or a joint data controller with an obligation to realise rights, consider, number one, diarise the deadline for disclosure. Secondly, collate the information. And it involves identifying material that contains personal data and isolating the personal data within the material. Consider the exemptions which apply and prevent the disclosure of the personal data, and prepare the material for disclosure and disclose it securely alongside the requisite information. So practically, recognise in any investigation that a DSAR is a significant risk. Doesn't always happen, but certainly it's not unusual, and prepare on that basis. So limit what you share and with whom. Ensure who remains the data controller in internal communications within an organisation. Consider deletion of material you don't need to retain, because if you've deleted it, you can't obviously provide it. I create an email folder for all communications, so I've got a ready means of identifying what communications I've had in order to then look at the extent to which personal data is there involved if I'm met with a DSAR. Consider express confidentiality terms in the terms of reference, because if counsel is bound by confidentiality obligations in the terms of reference, that's a valid basis upon which they can refuse to provide disclosure under the DSAR. And allocate responsibility for the DSAR in your terms of reference.